I raced back from Pittsburgh from my annual physical once I saw that the Deshaun Watson cases had settled. Not all of them, but most of them. 4 of the cases are not settled. 20 of the lawsuits are in the process of being resolved. It's not official yet, but once the deal is done between the lawyers, it very rarely falls apart. Once one of the lawyers puts out a public statement that the cases are resolved, rarely, it's not impossible, but rarely does that tentative deal become anything other than a final deal. So what does it mean? As a practical matter, it means 20 of the cases will now be gone. 4 will be left. 4 will move forward unless they're also settled. Once the defendant starts paying out money to settle cases, it makes it easier for the defendant to keep paying money. So maybe these other 4 believe that for them, justice is going to have a higher price tag than it has for the other 20. And maybe at some point they reach an agreement and the other 4 cases are also gone. I won't be surprised if we get to a point where the other 4 cases are gone. I got a couple of possibilities of how that can happen that I'll talk about in a minute. For now, the thing to remember is that there have been multiple opportunities for these cases to settle before the first case was ever even filed. Should have settled then. When Tony Buzbee contacted Athletes First, the firm that handles Deshaun Watson's football interests and also provided some initial legal services, seeking $100,000 in settlement, if they had just merely engaged him in a back and forth, they could have settled her case, and maybe there never would have been a case number 2 or 3 or 4 or so on. Instead, they refused to put anything on the table. They pissed off Tony Buzbee, and the next thing you know, there's more than 20 cases. So, yeah, in hindsight, if an opening demand is $100,000, chances are you could settle between 50 and 75. He should have done it. And as we said on PFT Live recently, cases like that get settled all the time and we never know about it because they never get filed, they never become a thing. That's the value in writing the check and cutting off a claim before it becomes a full-blown legal ordeal. Some people want to call that extortion. It is not. It's only extortion if you really don't intend to follow through with it, or if you say something like, I'm trying to think of an example here. I should have thought of one in advance, but basically you want money. Otherwise, you're going to do something that, is unrelated to pursuing your rights in court. They have every right to go to court to try to get justice for what they experienced. Pre-litigation settlement talks are not extortion. They're pre-litigation settlement talks. If you intend to go through with it, and if you do go through with it, if you don't settle the case, it's not extortion. It can never be extortion. And in many cases, the potential defendant is far better off writing the check, avoiding the legal fees, avoiding the publicity, and avoiding a settlement that ends up likely being much higher than what could have been reached at the time it all first came up. Then, after the 22 cases were filed, remember this phase 2 of potential settlement. The plaintiffs, led by attorney Tony Buzbee, wanted all of the payments to be confidential. Deshaun Watson and Rusty Hardin wanted no confidentiality provision. They basically wanted to do a victory lap. They wanted to dunk on Tony Buzbee and say, look how little he got. Look how small the amount was, which means Deshaun Watson didn't do anything. This was just a nuisance settlement. That's what they call it. It's a nuisance. We're making a nuisance go away. It's a minuscule amount of money relative to what we would spend on legal fees. It's a no-brainer. So he didn't do anything wrong. Well, it all fell apart over that failure to reach an agreement on confidentiality. So there went that opportunity to settle the cases, presumably for a lot less than they're settling now. Then came October. Dolphins want to trade for Deshaun Watson. Condition a trade on settlement of all the cases. All but 4 were ready to go. And I can't help but wonder whether it's the same 4 that held out then that are holding out now. At the time, there were 22. So there were 18 that were ready to settle. Deshaun Watson said, I don't want to do 18 and leave 4. I want to do them all. Well, he should have done 18 and defended the 4. And he didn't. He should have. He should have settled before they ever filed. He should have settled back in April of last year. He should have settled in October of last year. And he should have settled every single day up until today. He should have settled when the Browns traded him, or for him, didn't. Wisdom often never arrives at all. It should be welcomed even if it shows up late. It was the right move. Just last week, Deshaun Watson said, I want to clear my name. They asked him, do you want to settle these cases? No, I want to clear my name. His name's never going to be cleared. Sims and I talked about that. It's never going to be cleared. So just make these cases go away. Resolve these cases. Give these individuals their justice and move on. And the best part of it is, from the standpoint of how much time it's going to take to deal with these 4 cases that are left, this isn't something that's going to linger into 2024 or 2025. Good luck when you wall off the football season months of August through March. Good luck getting a bunch of cases done in one off season or 2 or even 3. Down to 4, they should be able to do it. They should be able to do it next year, assuming the cases don't settle. But I have a feeling that the 4 that are left will settle. They could settle in the short term. If they don't settle at all, they go to trial, obviously. There's a device under Texas law, and most states recognize this. It's called an offer of judgment. I'm going to write something about this at PFT. In a nutshell, what happens is, and I think we've talked about this months ago, but it becomes relevant now for the last 4. What you do is, if you're the defendant, and in Texas you can do it also if you're the plaintiff, you basically file the appropriate paperwork to say, I'll cry uncle. And let's say in this case, Deshaun Watson says to Ashley Solis, I will offer you judgment in the amount of $250,000. And that amount is intended to reflect everything: your compensation, litigation expenses, attorney's fees, everything. $250,000. Take it or leave it. Now, if she doesn't take it, what happens going forward is she suddenly has skin in the game. She suddenly has something to lose. We've all seen the commercials. We don't get paid unless we get money for you. She's not going to owe Tony Busby a penny if she fails to prevail at trial. You just walk away. Yeah, there'll be litigation costs, but most lawyers don't want to compound a bad situation for their client by saying, oh, by the way, you owe me $10,000 in litigation costs, even though I blew your case. Everybody just kind of walks away. That's it. It's over. It's done. It's not done if Deshaun Watson makes Ashley Solis or any of the other 4 remaining plaintiffs, 4 total, 3 others, an offer of judgment that they refuse to accept. And if they fail to get, and it's the way it's worded under Texas law, it has to be significantly less. The final amount is significantly less than what was offered. And there's a formula for that. If that happens, then the plaintiff owes Deshaun Watson all litigation expenses and attorney's fees incurred from the date of the offer going forward. That gives a plaintiff who otherwise has nothing to lose, something to lose. So once you explain that extra angle, once you make the plaintiff understand that additional wrinkle, all of a sudden, a settlement offer that maybe the plaintiff turns his or her nose up at becomes a lot more attractive. So I think that Deshaun Watson should do that. And I think the best time to do it is after the league locks in with its proposed suspension. Because when you make an offer of judgment, you are essentially saying, I did it. But it's more like no contest in the criminal context. But still, you are saying, I am willing to concede victory to you. Probably a good idea to wait to do that until after the NFL's disciplinary process gets started. Not that it makes a huge difference, but I think that would be the way I would strategically map it out if I were the one calling the shots. And Deshaun Watson should be. I'm not going to say he should be glad I'm not the one calling the shots, because frankly, if I was the one calling the shots, he'd have settled the case before the first one was ever filed. So this is one case where I won't make the snarky, self-deprecating remark, hey, he should be glad I wasn't. He should wish that somebody with my mindset was, because we wouldn't have known about any of this crap. It all would have been over. It all would have been done for a lot less than what he's paid in legal fees and a lot less than what he's going to pay out in settlements. We know it's at least got to be $100,000 each. He was going to pay $100,000 each back in October. Price didn't go down since then. Now, it's technically confidential, but I guarantee you this, somebody's going to blab. With one plaintiff, maybe they keep it quiet. Because if it gets out, who talked? The one plaintiff. You get 20? Who talked? Not me. It was one of the other 19. Okay, how about you? Not me. It was one of the other 29, one of the other 19. You can hide in the crowd. Somebody's going to blab at some point. Somebody's going to, and it would be wrong if it happens, but it will be right from the perspective of a news gathering organization. This is a conflict for me because I think these agreements should be respected. And too many times we see confidentiality agreements that were bargained for by lawyers. These aren't NDAs that are forced onto an employee, take it or leave it. This is something that was carefully and deliberately bargained for. They should be honored and respected. But I can tell you, somebody's going to blab. Somebody's going to talk. Somebody's going to say something. We're going to know the amount. And I suspect that if offers of judgment are made to Ashley Solis and the other 3 holdouts, there's a good chance that becomes public at some point as well. May not be public until after the verdict, but at some point we may know what was offered to them if that final offer of judgment is made, aimed at giving them something to lose. The Browns, this is good news for them because it moves the process closer to finality. They just want it to be over. They don't want this to hang over the team all of this season, next off season, next football season, the following off season, with all these cases going through the court system. They want the cases to be over. They want the suspension to be handed down. They want it to be served. And then they want to get back to the business of trying to win football games with Deshaun Watson as their franchise quarterback. So this is good news for the Browns. There's one other wrinkle here. It's important. Before I get to that, the league said today, and this is no surprise, that the settlements of these cases has no impact on the NFL's disciplinary process. No, it's apples and oranges. It's 2 separate things. He could have gone to trial and won every one of those cases and still been in violation of the personal conduct policy, not because he assaulted anyone or violated their rights, but because of this lifestyle of reportedly at least 66 different women from whom he procured private massages through Instagram. And according to his lawyer, who says it's not a crime to seek a happy ending, to conclude a massage, there's already been an admission that at least 3 of these massages became sexual encounters. So the NFL's position is completely different from what happens in the civil justice system. The NFL will still go forward. I believe there will still be a significant suspension. And it pushes the whole thing to being over sooner if you get the cases settled. Now, here's the point that I wanted to make. There still could be other lawsuits. Tony Buzbee hinted at that in a statement that he issued last week after Deshaun Watson met with reporters. There are many others who have not come forward yet. They still could. Now, I don't know what was said between Tony Buzbee and Rusty Hardin about this. And technically, you can't reduce to writing a commitment that, from Tony Buzbee's perspective, I'm out of the Deshaun Watson business. I'm not going to file any more lawsuits over these activities. Anybody else who's come to me, I'm just going to tell them I can't handle the case. Technically, he can't do it, but as a practical matter, if he wants to do it, he can. And that could be a gentleman's agreement. Hey, look, we get this here. You're not going to go file 15 more of these, right? This is over. We want this to be over. We got the 4 that are pending that haven't been settled, but there aren't going to be any others, right? Man to man. Give me your word, right? Again, it's unenforceable. And if it were reduced to writing, it would be an ethical violation for both of the lawyers. But I would want to know, if I'm Deshaun Watson, is this guy going to file more cases? Now, somebody else could file them. There could be others out there who come forward, especially once they find out how much Deshaun Watson paid when it inevitably is leaked, how much he's paying. That's why the defendant in these cases typically is the one that wants confidentiality. They don't want to start a revolving door. of claimant after claimant after claimant saying, give me mine, give me mine, give me mine. Who cares if my rights weren't violated? I want mine. You're giving it to them. Why not give it to me? So there still is a possibility others will sue, but there's also a possibility of a wink nod kind of an arrangement between Tony Buzbee and Rusty Hardin that Buzbee isn't going to be the one who files those lawsuits. So bottom line, look, technically it doesn't mean that Deshaun Watson did anything wrong, but there will be people who believe that the payment of any amount of money is a concession that there was misconduct. From my perspective, a lot of it is driven by how much, because there is an amount that you pay where you do a very dispassionate, objective analysis of how much it's going to cost you from now through the end of the litigation to defend yourself, how much it's going to cost you to buy out now. And if it's less, why not save some money and create some certainty and reduce this long list of lawsuits down to something more manageable? So I understand that people are going to assume that he's conceding he did something wrong, but it really doesn't mean that. And there will be language in the settlement agreement, not that we're ever going to see it, but I guarantee you it'll be a broad denial of any liability, clearly, unequivocally, no admission of misconduct by Deshaun Watson. That's a no-brainer. There are reasons to settle other than the person thinking, oh crap, I did it, and it's going to be exposed. He still could have won every one of those cases. He would have been a crapshoot, but he still could have.
Hi, I'm Mike Tirico, and thanks for watching. Make sure to hit subscribe for the latest news and highlights from NBC Sports.